Good morning, everybody, and welcome to today's webinar, Unfair Contract Terms, Law Changes Your Business Must Understand, which is proudly supported by Matthew's Folbigg Lawyers and our esteemed platinum partner. I'm delighted to see many of you joining us online today, and I'm confident this webinar will be packed with valuable insights for everybody. My name is Cassidy Lau, and I'm the Events and Membership Manager at Western Sydney Business Connection. Now, before we begin, I acknowledge that I'm hosting and recording this webinar from the lands of the Darug people. I acknowledge traditional custodians of the various lands on which you all work today and the Aboriginal and Torres Strait Islander people participating in this webinar. The Connection is proud to be partnering with 4 incredible businesses to ensure you have continued access to our webinars like the one today at little or no cost. I would like to thank Matthew's Folbigg Lawyers, Campbelltown City Council, Rare Kind, and world-class teams. Now, today we will learn about the latest changes to the Australian consumer law, particularly concerning unfair contract terms. These new laws have significant implications for the validity of standard contracts and can result to substantial penalties. We are fortunate to hear from 2 distinguished experts from Matthew's Folbigg Lawyers. Principal Lawyers Zeeshaan, Nordien, and Michael Stevens will be sharing their invaluable insights and provide an overview of the recent reforms, delve into case studies, and discuss the effective risk mitigation strategies to safeguard your business. Zeeshaan is a principal at Matthew's Folbigg Lawyers Commercial Law Group, and holds more than 19 years experience in business and commercial law. Zeeshaan has completed a Bachelor of Arts and Bachelor of Law at the University of Cape Town and is admitted in the High Court of South Africa and Supreme Court of New South Wales. Michael is a principal at Matthew's Folbigg Lawyers. He was admitted to practice law in 1997 and completed a Master's of Laws in 2007, specializing in corporate governance and insolvency. Michael operated his own law practice from 2014 prior to joining Matthew's Folbigg Lawyers in 2024 and understands the need for businesses to have a reliable and trusted legal and accountancy advisors. I'm delighted to welcome Zeeshaan and Michael today to present our webinar. Over to you.
Good morning. Thanks very much, Cassidy. Thanks everyone for joining us, and thanks to the Connection for hosting this webcast. Well, terms and conditions of contract form the basis of most commercial transactions and consumer relationships. It's something key to what us as lawyers deal with every day, and it should be central to a lot of your businesses as well. The law of unfair contract terms is designed to promote freedom of contract in a fair and equitable marketplace. So gone are the days where companies used to be able to just issue standard form contracts on a take it or leave it basis. If you now issue a standard form contract where there's an unfair imbalance in the bargaining power between the parties and there's no opportunity for negotiation, then bear in mind you'd likely be in breach of the new unfair contract terms regime. Now, there are 2 pieces of legislation that really govern this. There's the ASIC Act and the Competition and Consumer Act, which sets out the unfair contract term laws. Section 23 and 28 of the Australian Consumer Law in Schedule 2 of the Competition and Consumer Act, and then Subdivision BA in Part 2 of the ASIC Act. These provisions effectively just are mirrored provisions, and they're materially the same, except there's some variations, and also the sections at the end of those parts which set out types of contracts and terms to which the law doesn't necessarily apply. So the first question is, does the unfair contract terms law apply to all contracts? Well, not necessarily. They apply where a person enters into a standard form contract, where that's a consumer contract, or where it's a small business contract under the Australian consumer law. Under the ASIC Act, it applies where the contract involves a financial product or the supply or possible supply of financial services. Now, although the unfair contract terms law has only recently captured increased attention, it has been around for a number of years. The legislation came into operation as early as 2010 under both acts, and small business contracts were first introduced into the Australian consumer law in 2016. That was pursuant to one of the Treasury Legislation Amendment Acts. And what that did was it extended the unfair contract terms protection to small business contracts as well. In April 2021, we saw the unfair contract terms protections being expanded to also cover insurance contracts with consumers and small businesses. For insurance contracts, note that the law applies where those contracts were either entered into, varied, or renewed after the 5th of April 2021. But last year was the important milestone. Last year was the year that brought about significant change, which came into effect on the 9th of November 2023. And it was this change that altered the landscape and created all this hype and attention that the regime has now witnessed. So Schedule 2 of the Treasury Laws Amendment Act in 2022 introduced amendments that would strengthen and clarify the unfair contract terms provisions and reduce the prevalence of unfair contract terms in consumer and small business standard form contracts. The changes applied to standard form contracts were made, renewed, or varied after the 9th of November 2023. And what these changes did was the scope for eligible small businesses and this is probably why it affects most of you out there. Remember, it applies both to consumers and to businesses. But one of the biggest changes was that it changed the scope for eligible small businesses to enjoy protections under small business contracts. So by way of example, previously businesses that would fall within the small business definition and enjoy such protections simply needed less than 20 employees. The upfront cost payable under the contract had to be less than $300,000, and the contract required a duration of more than 12 months with upfront costs not exceeding $1 million. Now, back then, very few businesses would fall and meet those requirements. That has all changed. So the amendment to the Australian consumer law has now removed that monetary contract value that we've just mentioned. And in order to qualify nowadays, the threshold of the number of employees has increased to fewer than 100 employees at the time of the contract. And it also looks at whether your annual turnover is less than $10 million for the previous income year. What's more is that it's only one party to the contract that needs to satisfy these conditions. So you'll see just by that change, the scope has been widened significantly. Under the ASIC Act and the Australian consumer law, it now includes a consumer contract where an individual acquires a financial product or services, wholly or predominantly for personal, domestic, or household use. And a small business contract would entail an upfront price payable of no more than $5 million under the ASIC Act in respect of financial products and financial services. Another big change that we saw was the significant civil penalties that we introduced. So if you're breaching the unfair contract terms, these new penalties will apply to all contracts that were entered into after 9th of November 2023, or contracts that are renewed or varied after the 9th of November 2023. So a corporation found to be in contravention of the Australian consumer law under this new regime would face maximal penalties of either the higher of $50 million, 3 times the value of the reasonably attributable benefit obtained by the company from the conduct. And if the court cannot determine the benefit, 30% of the adjusted turnover during the breach period. So remember, it's the highest of those 3 in the case of corporations. For individuals, the maximum penalty increased from $500,000 to $2.5 million. So those penalties should be enough to say, we need to make sure that our contract terms are fair. Section 23 of the Australian consumer law says that a term of a consumer contract or a small business contract is void if that term is unfair, if the term is a standard form contract. And Section 12BF of the ASIC Act says very much the same, but it also says that it applies where the contract relates to a financial product or where it's a contract for the supply or possible supply of services that are financial services. Now, when we're looking at all these requirements and all this legislation, we need to understand all the terms. So for these purposes, what is a consumer? A consumer would be, in the case of a business, would be considered to be a consumer where the goods and services for the business are under $100,000, or if it's for personal use, domestic use, or household use, regardless of the value. A consumer contract is another term we need to understand, and a consumer contract is a contract for the supply of goods and services, the sale or grant of an interest in land to an individual for personal, domestic, or household use and consumption. The important one for most of you that are involved in business contracts with small businesses is, what is a small business contract? So that a contract is a small business contract if the contract is for the supply of goods or services, or a sale or grant of an interest in land, and at least one party to the contract satisfies the requirement which I spoke about a bit earlier, which is the minimum number of employees, so that's employees fewer than 100 people, or the annual turnover of less than $10 million, and that relates to the previous income year. When you're counting employees, note that it would be the number of employees at the time the contract was entered. It does take into account casual employees, but it does not take into account employees of any related business. So the question when we're looking at this is, what would we consider the test when we're considering unfair contract terms? Well, the first question is it a standard form contract? If so, does the contract meet the requirements of the consumer contract or the small business contract that we just mentioned? Does the term fall with any of those statutory exclusions that's referred to in the Act? And if not, then the term is unfair. Is it unfair, is the question. Now, the standard form contract it's not defined in legislation. What we need to bear in mind, though, is there's this presumption under the Act that says if a party alleges that a contract is a standard form contract, it's presumed to be one, unless it's proven otherwise. And it would be up to the other party to rebut that presumption. Now, Section 27 of the Australian Consumer Law and the mirroring Section 12B of the ASIC Act set out various matters that should be taken into account when determining whether a contract is a standard form contract or not. So these factors would include whether a party has all or most of the bargaining power relating to the transaction, if one of the parties has created and agreed a substantially similar contract with another client, for example, if that party's prepared a contract before any discussion or negotiations relating to the transaction with the other party or the consumer, if a party was required to accept, in this case, the consumer, for example, was required to accept or reject the contract terms as provided, and if a party was not given an effective opportunity to negotiate the terms of the contract. Also, it refers to the characteristics of the contract. So did the contract terms consider any characteristics specific to that transaction or to that party? So the type of contract that is often used repeatedly and generally offered on a take it or leave it basis would be considered to be a standard form contract. And I think a lot of contracts that we see these days would fall within that description that I've just referred to. So considering this wide net cast and the presumption that it is a standard form contract, there's a very good chance that it could be one, and it's therefore very important that we make sure that the terms of the contract are not unfair for us not to be susceptible to any claims that may arise under this new regime, or rather just the unfair contract terms regime. So what makes a contract term fair? What makes a contract term unfair? Well, this meaning, again, it's articulated in the legislation. So Section 24 of the Australian Consumer Law and Section 12BG of the ASIC Act. And the questions are, would it cause a significant imbalance in the parties' rights and obligations under the contract? If the term is not reasonably necessary to protect the legitimate interests of the party that would benefit from the term, or if it would cause detriment, whether financial or otherwise, to the consumer if it were to be relied on. So those are the key factors that would regard a term to be unfair. In addition to that, the legislation says we need to have regard to whether the term or the contract is transparent, and we need to regard the contract as a whole. And again, it gives us some guidelines in the legislation as what's meant by transparent. So it needs to be legible, must be in reasonably plain language, it must be presented clearly, and it must be readily available to any party that's affected by it. And like I said, the contract would be considered as a whole. The legislation also sets out some examples of unfair terms. This is under Section 25 and Section 12BH of the ASIC Act. And some of these examples would be included. Again, it looks at the balance of it. So it says terms where one party for example, but not the other party, can limit the performance of the contract obligations. One party can unilaterally terminate the contract. One party can penalize the other party for breach of the contract or termination of the contract, only being that party. One party can unilaterally vary the terms of the contract or price under the contract. One party could vary the characteristics of the goods or services being supplied. One party would be able to decide whether or not to renew the contract. That same party would be able to assign, transfer, or novate the contract without the consent of the other party, possibly determine whether the contract has been breached, or determine what the meaning of that breach would be. Or one party could unilaterally limit the other party's rights to sue. So you'd see these are all very one-sided examples, and it's all about the balance. So essentially, it would be the terms that create an imbalance of the contractual rights, potentially to the detriment of the other party, normally the consumer or the small business who was presented with the contract. Now, there are certain terms that are not covered by the unfair contract terms law, and these are again set out in the legislation. Some of these terms are terms that would be defining the main subject matter of the contract. For example, describing the product or service being acquired. Another term would be setting the upfront price payable, being the amount disclosed that's being payable under the contract. And then others would be terms that are required or expressly permitted by law under any other legislation or any other laws. The legislation also sets out certain contracts that are not covered by the legislation, and these are set out in Section 28 of the Australian Consumer Law and the ASIC Act. Under the acts, it would, for example, include contracts of marine salvage or towage, contracts for carriage of goods or ships, goods by ship, constitutions of companies, managed investment schemes or other kinds of bodies, and then, of course, medical indemnity insurance contracts. There's a bit of an extension under the ASIC Act about excluded contracts that are not covered, and these would be insurance contracts that are not for financial products or services. It would be guaranteed renewable life insurance policies made or entered into before the change came about on the 5th of April, 2021. And then there's certain contracts as well that are connected with financial markets. I'm going to hand it over to Michael now. He's going to explore some of the recent cases because there's been quite a few developments in this area of law since the change last year. So he'll be exploring the recent cases. He'll be considering the contracts that are actually subject to these unfair contract terms regimes, and also some of the practical considerations for businesses like yourselves relying on standard form contracts.
Thanks, Zeeshaan. Hi, everyone. I'm Michael Stevens, Principal as well of Matthews Folbigg. This is an interesting topic, and it's brought everything to a head. The penalties coming in now from the 9th of November 2023. We're seeing cases being decided at this stage where there's been no pecuniary penalties because the contracts haven't been renewed or entered into after the 9th of November 2023. So we're keeping a lookout for these new cases coming that will be incurring financial penalties, but I'll run through 3 examples. But there on this page is just under the Australian Consumer Law. If an individual is relying upon an unfair term of a contract, like a sole trader or a small business that's just operating as a sole trader, the penalty is $2.5 million. Now, that's pretty expensive. The penalties that will be incurred will depend on how often the parties are relying on these unfair terms in the past and the detriment caused to the other party. But the unfair terms obviously have to be proven that there's been a change in rights. So unless the rights are mutual rights, you're going to be in breach. The party that suffers from the term that you're relying on suffers a detriment. Now, the detriment may be financial, or it may be, which the courts have decided, is loss of a right, an imbalance of rights. And is the term necessary to protect your interests? So it's a pretty low bar to prove that a term is an unfair term. Before the consumer legislation, you had to rely on, under the Competition Consumer Act, harsh, unjust, unreasonable terms. Now it's a lot easier. So a lot of firms that we've come across, businesses, are getting their terms checked when they renew them. So An individual under the Australian consumer law is $2.5 million. The company is up to $50 million. That it's got to be pretty rare that it's got to be that amount. That'd be for large organisations giving their terms to a small business. And the ASIC is slightly different, but the ASIC applies, which is of interest to me, to insurance contracts, which I think will be a hot topic in the courts coming up, and to financial services, bank loans, bank deposits, credit contracts. So the first case that I want to talk about is the Carnival cruise, the COVID March 2020 Ruby Princess. A US group of passengers signed a contract with Carnival, an overseas-based business in America. They came to Australia, went on the cruise, March 2020, contracted COVID. They issued a class action, an action altogether in the Australian courts, seeking damages, a loss of enjoyment of the cruise. Carnival, in my view, the benefit of hindsight, challenged that class action suit, saying that the terms and conditions only allowed claims to be issued in America, an exclusive jurisdiction clause, and they couldn't issue class actions. They had to issue individual claims. That just seems like an unfair contract term. That's the benefit of hindsight, obviously. But the first court, the federal court, said that the term was unfair. You couldn't bar an individual's rights to join together in a class action. The full federal court said, no, we agree with Carnival. That's protecting their rights. It went to the High Court. The High Court said it is unfair because there's a significant imbalance of the parties' rights. We're going through the checklist now. The term wasn't reasonably necessary to protect Carnival's interests because individuals could claim on their own. They can be allowed to join a class action suit as well. And there was detriment caused to the customers because they lost their rights to claim on their own behalf. So it was obviously an unfair contract. The reason why it made it to the High Court was that there was another matter which is highly relevant to probably most people that are listening, is if you're dealing with an overseas business, Australian laws and regulations apply if they want to do business in Australia. Carnival said the unfair contract terms don't apply because we're an overseas business. The contract was signed with US customers, passengers. It doesn't apply. The High Court said, if you want to do business in Australia, you have to comply with our laws. So that will affect, that's why that case is here. That's going to affect a lot of your respective business dealings with your customers and or if you're an overseas-based entity yourself. The exclusive jurisdiction clause saying that you could only claim in America wasn't dealt with. The court's got a discretion to say whether they allowed that exclusive jurisdiction clause to hold up. They said it's their discretion. They didn't say it's an unfair contract term, so you can have exclusive jurisdiction clauses in your contracts. But they said because the passengers had already issued proceedings in Australia, they're going to allow those proceedings to continue. So they didn't enforce the exclusive jurisdiction clause, but they didn't say it's an unfair term. So technically you could have an exclusive jurisdiction clause in your terms and conditions. The next case, which is subject to appeal, is an insurance, home and contents insurance policy where ASIC, so this falls under the ASIC regime for insurance contracts, credit contracts, bank loans, financial services up to $5 million. Like most insurance policies, the insured, the customer that's being insured, has a duty to disclose of any significant changes to their circumstances that may affect the policy. It's in most insurance contracts. Under the Insurance Contracts Act, which governs insurance policies, there's a duty of utmost good faith, obviously, and this clause is in pretty much every insurance contract. If the insured should disclose a material event, they need to disclose it during the course of the term of the policy. ASIC, on behalf of the consumers, said that this was unclear. It should define what needs to be disclosed. It creates an imbalance in the parties' rights where the consumer may be disadvantaged by not disclosing if it doesn't know what to disclose. And it's not reasonably necessary to protect the insurer's interests. The court sided with the insurance company on the basis that, and this is the interesting bit, it said the Insurance Contracts Act 1984 governs the rights and regulations in respect of the parties. There's a duty of utmost good faith and disclosure in the Insurance Contracts Act. So the court basically said that trumped the unfair contract terms regime. ASIC weren't happy about that. They've appealed it. It was due to be heard on the 28th of August. I'm waiting for an update unless it's settled, which I don't think it would be, and I'll get to ASIC's position on unfair contract terms. I'm waiting to see what the outcome of that full federal court hearing was. But the interesting part of that case is the court referred to another piece of legislation in relation to, well, that applies ahead of the unfair contract terms. I don't think that's right. I think the full federal court will overturn it, but we'll see. So the last case is the PayPal case. Again, ASIC, because it's a financial services case. They had a clause that said that if we overcharge you and you don't tell us in 60 days, we get to keep that money. Now, that's unfair. But it's probably been a precedent in a lot of financial services contracts where, I don't know actually if it is or not, but that seems like an unfair term. So the court obviously found that that was obviously unfair. It changed the rights between the parties because it removed the right of the customer to challenge after 60 days. If you're going to change rights in a contract, it needs to be mutual rights as far as it can be fair and practical in these contracts. And the fees charged couldn't be properly deciphered by the customers when they were charging for a range of fees each month. PayPal, they said, was in a better position to decipher which fees were overcharged, and they should have notified them when they were overcharged. So based on the contract as a whole, the court said PayPal was in a better position to determine if fees had been overcharged because they were the ones that were issuing those fees. So they went through 3 circumstances again. So if you get anything out of this presentation today, what's an unfair term? It changes the rights. That's a significant imbalance. It causes detriment to the consumer or the small business, and detriment can be financial or a loss of a right to sue. And the term is not reasonably necessary to protect the interests of the party that's seeking to rely on those clauses. So the thing that I found interesting in this case is that PayPal, once this claim had been issued, PayPal voluntarily removed that clause from all their contracts and notified their customers that they weren't relying on that. ASIC sought leave of the court to proceed to a final hearing and get a judgment in this matter. The court allowed it in respect of public policy grounds, I can only presume, but it shows ASIC's determination to get the message out here that in relation to financial services, credit contracts, consumer, I'll get to loans and business loans, which are largely unregulated, not by the National Consumer Code, ASIC will be looking at these matters and seeking at first instance to go through to final hearing so it gets these judgments out into the public sphere. So beware of ASIC and also the Australian consumer legislation. This is probably a bit surprising when I first started looking at this when the unfair contracts legislation came out back in 2010. It applies and it's continued to expand now because it's expanded to small business and there's no monetary value on the contracts anymore. It applies to most businesses, and it applies to every invitee that's watching this presentation now. I've gone through the list, including the government organisations that are dealing with small businesses, obviously, and consumers. I was trying to think that the only thing that these unfair contract terms may not apply to would be government public-private partnerships, where the business is turning over more than $10 million and dealing with governments for tenders, etc. Unfair contract terms wouldn't apply. But if you're a builder, employment contract, probably our cost agreements. The interesting thing that will have a big effect is the international software license agreements, the American terms that I think they're unfair, but they never seek to amend. The insurance contracts will be a hot topic, building contracts, standard terms and conditions. So if you're concerned, you need to remember what makes an unfair contract term. And it's those three things again. I'll just keep on going back to, it's the significant imbalance, the change of the party's rights in favour of one party. Does it cause detriment, which would mean a loss of the right to sue? And is it reasonably necessary? So as you can see there, it affects a lot of different businesses, and every business that's listening and sole trader to this presentation. So you may have an unfair contract, you think, but the court will consider the contract as a whole. So, for instance, a lot of contracts, software service contracts, essential service contracts, have an automatic rollover period unless you provide written notice that you don't want to continue that contract. If it is for an essential service, they may get away with having an automatic rollover of a contract unless you provide written notice. For most contracts, the courts will look dimly, unfortunately, at the automatic rollover provision. So the other terms that I've seen that are just going back through my previous reviews in the last couple of weeks, unjust fees for returns of goods and services. They charge a 20% cost for the fee incurred. That's an unjust fee. Documents, terms and conditions referring to other policies, other that are on their website. That's a common enough practice. The courts may not necessarily like that if that is difficult to obtain or access by the client. So at least you have to have different policy and guidelines that you refer to in your terms and conditions on your actual websites. The other terms that I've found are that the supplier has the right to change the terms and conditions throughout the course of the agreement. That's not right. The only way that could not be unfair is if you allow the customer to change the terms and conditions during the term of the agreement. Obviously, that's not going to happen. So there's a lot of different terms that are in a lot of the contracts that we're reviewing through different organisations, including building contracts, that the courts will consider to be unfair. So we all need to review our contracts to ensure that you avoid any scrutiny or complaints from your customers, because customers will now be being marketed to in relation to these unfair contract terms by business networking authorities and lawyers trying to generate some work. So the customers will be becoming educated as well. So ASIC, only the courts can determine that a term is unfair. So it is a process for a term to be held to be unfair if it's not agreed between the consumer and the service, or the small business and the service provider. So there will be an opportunity to negotiate. The best negotiating tool that you will have if you receive a complaint is that you will provide an undertaking not to enforce or exercise those rights if they consider, and you consider, through your own investigation or with advice, that term could be perceived to be unfair. You can change those terms when you renew the contracts or enter into new contracts with your customers. That is apart from seeking legal advice, obviously you have to keep your customers happy, but should you be disclosing now without complaint terms that you perceive to be unfair, that's a commercial decision that you will have to make. But it's easier to ensure that your new contracts and your renewed contracts don't have these unfair terms, because it'll become commonplace now. In about 2 or 3 years' time, the case law will set out what is fair and unfair in relation to these contracts. The other one that I've seen, obviously, is indemnities in favour of the service provider. They need to be mutual, suspension or termination for convenience. That is probably okay if you have a cost clause that you pay for the reasonable costs incurred. Termination or suspension for events outside the party's control is okay. That's a force majeure clause, but that's come under some interest by the courts, that it has to be a mutual right to terminate or suspend for events outside the control, and entire agreement clauses, which it basically means that the terms of this contract apply and no other terms, representations, implied warranties apply. If you're going to have an entire agreement clause, which I don't think you do, because if it gets to a contested dispute, the courts will say, well, the contract forms the basis of the agreement, and it will allow pre-statement representations. So don't put pre-contract representations being excluded, because that will be, in my view, an unfair term. If you have an entire agreement clause, keep it short. This agreement is the entire agreement between the parties. That's it. It's not worth having, in my opinion. So, but we will see. We're keeping an interest in the cases coming out, and I'm interested in the insurance case that was to be listed on the 28th of August, the ASIC and Auto General Insurance, Home and Contents Insurance Policy. So I'll keep an eye out for that. That is probably a little bit short, but that's okay. That's us now. But our probably best advice to you is that if you do receive a complaint from a customer about unfair contract terms, the best that you could do at this stage is you say to them that you're not going to enforce that clause and that you'll amend the terms going forward. Thank you.
Thank you. Well, I guess the key takeaway for you is, look, if you look at what we've spoken about and look at the legislation, there really is a common sense approach to it. You know, and if a term feels to be unfair to you, it probably is, and rather err on the side of caution. Get in touch and get some legal advice about the contract and consider whether you want to have it reviewed. And, you know, I'm not saying it just because this is what we do, but it is prudent that everyone out there that relies on standard form contracts, and I'd say it's probably the vast majority of you, should be reviewing them now and getting some advice on them to make sure that you are on the right side of this new regime, or the revised regime rather. Thank you.
So, well, thank you, Zeeshaan and Michael. I'm just going to this. So if anyone has any questions they'd like to ask our speakers, just pop it in our Q&A box below. And while we wait for questions to be submitted, Zeeshaan and Michael have kindly shared their presentation slides, and these will be available along with our webinar after the session. So keep an eye out for that email. Now we just have a couple questions coming through. So the first one we have is, where can I find a standard contract template?
Well, that's something that we wouldn't be advising you to do. I don't think that there is any specific standard contract template that we could recommend generally, because we would draft them in accordance with a specific industry, in accordance with the specific requirements. So I wouldn't be able to direct you to a standard contract template as such. What I would say though is, speak to, I'm not sure what sort of industry the person asking the question is in, but sometimes in the industry, there are recommended templates out there by various regulatory bodies. And if there isn't one available by one of those bodies, speak to your solicitor or speak to us or someone to assist you in drafting a template specific to your business.
Thank you, Zeeshaan. Now, the next question is, what happens if you are the supplier and the third party, example, pre-processor, terms that need to be flowed down to the customer that you're not in position to change?
That it's the party that's seeking to rely on the terms that would have to respond to it. However, the person in the middle that's asked the question of that, they're the subcontractor, I presume, maybe guessing in the building industry, but I could be wrong, but it's nice to go. But if the person in the middle, the subcontractor, is getting any benefit out of that clause, they too could be a second liable party, basically. But if you obtain any benefit out of that clause, you may be liable to the ultimate customer.
All right, thank you, Michael. Going back to the first question that we had regarding a standard contract template. So the anonymous attendee mentioned that they're in the general retail industry. So again, I think maybe reach out to you guys.
Reach out to us and we can consider your industry specifically, because you say you're in general retail, but retail is a very broad industry. And depending on the nature of the contract, there might be legislation that governs it as well.
Correct. Awesome. Thanks.
So I'd say, reach out to us and let us know a bit more about your business and the industry.
Sounds good. Now, the next question. In a preschool setting, we have conditions for bonds to be kept if not sufficient notice given. If someone says that the lack of notice was beyond their control, do we have to release the bond?
That's two things, right? That's a force majeure clause. Beyond control, and then also the unreasonable withholding the bond.
Yeah, I think that it's not the upfront price payable. That's just a bond for the security for unpaid fees. If you don't provide the requisite notice period, I think they probably would have grounds. If they provided the service, they would have grounds to keep that bond. Is that in the childcare industry, was it?
Yes, that would be.
What do you think?
Well, the childcare industry has specific legislation, both state and federal, that governs it. So you'd need to look at that as well.
Yeah.
But I think if I don't know if you'd be able to unilaterally just retain the entire bond, but if part of the bond or the entire bond is commensurate with the actual detriment caused to the childcare centre, then possibly, the question is, would it be reasonably necessary in the circumstances? But again, we need to, there'd probably be a lot more that we need to consider there. We need to consider the circumstances surrounding it. Why was the notice not given? What are the reasons that you want to retain the bond? It would need to be considered fully.
Thank you, Zeeshaan. Then that's all the questions that we have at the moment. Again, if anyone has any questions, just submit it through the Q&A box below. While we do have a couple of minutes, I might just mention that we do have a breakfast masterclass coming up next week, September 12th. World-class teams will be providing strategies on inclusive leadership, how to bring the best out of different generations, cultures, and personality types. You'll learn how to bridge generational gaps, but manage multicultural workforce, handle personality differences, and improve communication to create a unified and productive team. So reach out to myself or head to our website to register for that one. Now, we do have another question that's come through again. Now, someone has asked, how can we have our contracts checked?
Very easily. Send it through to a lawyer. Could be us if you'd like to engage us to assist with it. If you'd like to reach out to us at the end of the presentation that we just put out there, we've got contact details for Michael and myself. So you're welcome to email us both. We can chat amongst ourselves about it. Come back to you with sort of preliminary way forward. And then you can engage us to review it on your behalf.
Sounds good. So yes, so Zeeshaan and Michael's contact details will be provided with the recording and our presentation slides as well for today. Just wait a couple more minutes for any other questions to come through.
Yeah, just with that last question, I mean, they should just do a sense check themselves. So just if that person's still listening, it's an unfair term if it's not reasonably necessary to protect your interests. So there's other terms in the contract that protect your interest. It changes the rights between the parties. So it in your favour, if you're relying on that term, it's not mutual rights, and that it causes harm, financial or otherwise, to the customer. So just those three things, and most of the time, it's your business. You'll be able to know whether it's unfair or not, going through those guidelines. So,
sounds good. And again, if you have any further questions, reach out to Zeeshaan and Michael. Now, we do have another question here. If there is a clause that is reasonably required to protect your interests, but isn't mutual, is it acceptable?
That's a great question. It's not mutual. Well, one of the three indicia or issues that we have to be proved is there's an imbalance in the parties' rights. So I've seen in a couple of judgments that there has to be mutuality. It has to be mutual as far as possible rights between the parties. So obviously the easier one is termination. Both parties should have a right of termination for default, etc. If it's reasonably necessary to protect your rights. And what was the other bit of the question?
So if it isn't mutual, is it acceptable?
And it's reasonably necessary to protect your rights. Well, correct.
Let's say possibly, yes. Wasn't there, I don't think we put this case down, but wasn't there an insurance case where it was recently considered they would be allowed for the insurer to up the premiums where the risk had changed?
Yeah. We'd have to have a look at the other terms of your contract to see whether you had rights that protected your interests. I'd be surprised if there weren't other rights in your contract that protected your interests.
Yep, that makes sense.
Yeah, I don't like it, but
no.
The answer would be possibly depending on the circumstances.
Agreed. All right, we'll wait a couple of minutes for any other questions to come through.
The other interesting, so my topics that I'm interested in are the insurance contracts, financial services, the credit contracts, unregulated business loans, franchise agreements. I'm waiting because franchise agreements, like a lot of different industries, they're governed by that franchisor code of conduct. So will that take, the courts will look at, compliance with the franchisor code of conduct in relation to determining unfair terms as well. Like that insurance case, ASIC and Auto General Insurance, the Insurance Contracts Act trumped the unfair contract terms. So that's subject to ongoing finalisation. So.
Cool. I don't think there's any other questions that are coming through. Now, oh, never mind, we've got one here. Now, the question someone has asked, we have had your team write our employment agreements. Will these need to be reviewed / change? They are in the automotive industry.
Hopefully not. We better have a look.
Yeah, I think probably not. We probably want to consult with our employment law team to consider that in more detail. But at the outset, it doesn't sound to me like it's necessarily a standard form contract, does it? That could be the first question. And, does it meet any other parts of the test? Do we know when it was drafted? Was it drafted pre-2023?
Not too sure.
If it was drafted before the change last year, I'd say it would be worthwhile for us to just have a second look at it, or further look at it, sure that if it is a standard form contract, or if it's deemed to be a standard form contract, that
Yeah.
it is.
So I think they've just mentioned yes to your question. So it was.
Okay.
Look, I'm sure the unfair contracts regime's been around since 2010.
10,
So,
I think.
there is little opportunity to negotiate changes in an employment law agreement. So this is the issue, and this is why this has got a wider scope now than trying to prove that a term's unjust, unfair, oppressive. If it's a standard form contract, which most contracts are, you can negotiate the schedule to the contract, which is obviously your work from home days requested, annual leave. If you're negotiating that will take it out of the realm, in my opinion, as a pro forma standard contract. But our employment team can, if you contact them and ask that question, I'm sure they'll be able to answer it.
Definitely.
Yeah, sounds good. All right. I think that's all the questions for today. So just wait another minute or so if anyone's typing up any questions. No, I don't think there's any other questions. So I'll conclude the webinar today. Thank you, Zeeshaan and Michael, for your time today, and Matthew Folbigg for supporting this webinar. Again, I've mentioned about our breakfast masterclass, so head on to our website if you are interested to register for that. Also, save the date for our next Business Leader Luncheon on the 24th of October. That will be held in Parramatta and sponsored by University of Sydney. We'll be exploring the future of education and what it means for Western Sydney. Again, more information will be found on our website or email myself. I'd also like to thank all our members and guests for their attendance today and your ongoing support. Thank you, everybody, and have a good day.
Thank you.
Thank you.
Thank you.